Imagine a world where clergy confidentiality laws are drastically altered. Suddenly, the trusted confessional booth is not a sanctuary of untold secrets anymore. We are talking about a lawsuit against the Church of Jesus Christ of Latter-day Saints in Arizona, a case that could potentially flip the tables on these long-standing laws. This case isn't just about one church or one state, but could set a precedent affecting clergy across the country, even the globe. This is not a hypothetical situation, but a very real case unfolding in Arizona. Let's dive into the heart of the matter, the case itself. Our story begins with a church member of the Church of Jesus Christ of Latter-day Saints in Arizona. This member, whose identity remains protected, confessed to an act of child molestation. Now, this confession wasn't made to law enforcement or a therapist, but to a clergy member within the church. As per the current statute, clergy members are protected from disclosing such confessions, allowing this church member's actions to remain unreported. For years, the abuse continued, hidden in the shadows of confidentiality. Enter stage right, attorney David Abney. Abney took up the case, arguing against the constitutional validity of this statute. In his view, the law unfairly grants special privileges to clergy that other counselors such as therapists or social workers do not have. He argues that this protection of confidentiality, in this case, allowed for the continuation of child abuse, a deeply troubling consequence. Meanwhile, the church counters this challenge with a defense of their own. They argue that the privilege is constitutional, based on the freedom of religion, and should not be applied retroactively. This means that even if the statute were to be changed now, it should not affect cases that have occurred in the past under the previous law. This brings us to where we are today, with the court yet to make a decision. The implications of this case are profound and far-reaching. At the heart of this legal battle lies the intersection of religious freedom and child protection. If the court rules in favor of the plaintiff, it could potentially reshape the landscape of clergy confidentiality laws, not just in Arizona, but across the United States. The argument, presented by attorney David Abney, that the existing law is unconstitutional because it grants special privileges to clergy that other counselors do not have, is a powerful one. This case could set a precedent, influencing similar cases in the future. It could prompt a reassessment of the balance between the rights of religious institutions and the necessity to protect vulnerable individuals. It could lead to a reevaluation of the limits of clergy privilege and potentially a redefinition of its boundaries. As we wait for the court's decision, we are left to ponder the potential ripple effects of this case on clergy confidentiality laws and beyond.